All right, welcome to the Chapter 7 video lecture on hearsay. So first up, hearsay's definition is that, or the concept behind hearsay is that hearsay is something a witness has heard someone else say rather than what the witness has personally seen or perceived. So in other words, this is coming from another person, okay? So federal rules of evidence define hearsay as a statement that the declarant does not make while testifying at the current trial or hearing. And a party offers, hearsay is something that a party offers in evidence to prove the truth of the matter asserted in the statement. So rumors are a good example of hearsay. And it matters for hearsay why you're offering it. So if you're saying, well, I heard my wife say she saw this happen, that's hearsay, and it's being offered to prove that what the wife saw happen actually occurred in that context. So that is hearsay. Hearsay rule generally prohibits hearsay, but there are a lot of exceptions. And this results in a lot of hearsay statements being admitted into court. Many statements that officers, correctional officers, police officers take from witnesses, victims, suspects, and other officers are hearsay. For example, the reports written by law enforcement professionals are hearsay or contain hearsay. So hearsay is really common. And again, I think it really helps to think of hearsay as a rumor. Because hearsay is an out-of-court statement, questions and issues of truthfulness and also accuracy to a certain extent are at issue, because one of the key principles, one of the key reasons we don't let hearsay in is because the person who actually said the statement is not in court under oath and subject to cross-examination. And in criminal cases, this can violate the Sixth Amendment, the Confrontation Clause, that the defendant has the right to confront those witnesses against him. Now, it's not applied literally, because otherwise, anytime the declarant, the out-of-court party, couldn't be in court, none of that evidence would ever come in, but the substance matters. We need to make sure that this person has been under oath and the defense has a chance to cross-examine. Supreme Court has considered the constitutionality of the numerous hearsay connections, and until March 2014 has found most of those exceptions to still be constitutional. In Crawford v. Washington, 2004, the Supreme Court said that the Confrontation Clause bans at trial the use of uncross-examined statements of absent declarants where those statements are testimonial. So in other words, when someone who is not in court makes a statement, and that statement is testimonial, something we want the jury to take as evidence, that violates the defendant's Confrontation Clause rights, okay? So, Confrontation Clause clearly bans statements made in the form of testimony at a formal proceeding given to police or other government personnel during an interrogation. It can also apply to statements made under circumstances that would lead an objective witness to believe the statement might be used later on at trial, okay? And testimonial really matters here for this definition. So statements are non-testimonial when made in the course of a police interrogation or under other circumstances indicating the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. So in other words, it matters the intent of the reason why the statement was taken. If it's an interrogation to resolve, and particularly to get at an ongoing emergency, for instance, there is a gun in a grocery store and police need to find that gun right away, that is not testimonial. Now, statements taken from victims and witnesses cannot be used at trial if the witness is unavailable for cross-examination at the trial and they have not been previously cross-examined by the defendant, unless they were made to assist police in an ongoing emergency, they are a dying declaration, or the defendant intentionally caused the victims to be absent from trial. Okay? So, we've got a lot of components going on. So, looking back, hearsay is a statement, an out-of-court statement made, offered for the truth of the matter asserted. Looking at a specific part of a statement, only evidence that's in the form of a statement not presently made in court can be hearsay. If the evidence is in other formats, like the present testimony in court, more tangible physical object, then hearsay does not apply. An out-of-court statement is hearsay when it depends on the credibility of the speaker for their truthfulness, regardless of the intent of the person who spoke it. Okay, and it's really important to look at, is this offered for the truth of the matter asserted or not? If a statement helps prove a fact, only if it's true, then it's hearsay. Now, okay, we'll just leave it there actually. Now, exceptions and exemptions to the hearsay rule. There are a lot of exceptions, and these generally are situations where there's a high level of trustworthiness in the statement. So Federal Rules 803, 804, and 807 contain the exceptions, including dying declarations, spontaneous declarations, state of mind, statements for purposes of medical diagnosis and treatment, and former testimony, as well as business records, pedigree, past memory recorded, prior statements of witnesses, opposing party statements and confessions, and declarations against interests. So your book has this nice little chart about how to figure out what is hearsay and what is not. So do we have a statement? If we don't, it's not hearsay. If we do, was it out of court? If it was, then we need to ask, is it offered for the truth of the matter asserted? Was it a witness's prior statement? So this is a really helpful little graphic to work through. Now, when we're testing a statement, there are two ways to figure out whether this is being offered for the truth of the matter asserted. One is just the fact that it was made or heard can tend to establish a fact, right? That you heard it makes you believe it. And the content of the statement may need to be actually true in order to prove a fact. There are some statements that are not offered for the truth of the matter asserted. These are operative legal facts, state of mind of the hearer, state of mind of the declarant, state of mind of the declarant on the traces of mind theory, and statements that are otherwise not on the truth of the matter but offer to prove something else, like impeachment. Okay? So operative legal facts are statements that create or destroys a legal relationship. Like, I will pay you $5,000 if you will kill V. Okay, that is a crime, and it's an operative legal fact. Okay. State of the mind of a hearer is a statement that affects the mind of someone else who heard it. So if the defendant heard another man say the victim was violent, who always carried a knife, that they thought of this person as violent is not for the truth of the matter. It is not hearsay. State of the mind of the declarant shows a person was not, often is used to show the state of the mind of the person who said it, not the person who heard it. And so if someone claimed that they were a dead historical figure, like Henry VIII, that can be offered to demonstrate that the person was suffering from a delusion. Okay, It's not the truth of the matter asserted, it's that a statement was made and this is the inference. Traces of mind theory looks into that the declarant had knowledge that they could have only gained by actually having perceived an unusual event, a circumstance, or surrounding. For example, a young girl's been kidnapped and locked up in a room. The child is then released and describes the content of the room to an investigating officer. The description of the room can be offered to demonstrate that the child was in the room. Because we have an inference here that this child could not have knowledge of what the room looked like and the contents unless they had actually been in the room at some point. Okay, so it's not being offered to prove that the kidnapping occurred. It's being offered to prove that the child was in the room. So different distinctions. Statements offered to prove something other than the truth of the matter. So anytime it's offered for another reason, it is not hearsay and it's admissible if it's relevant. So a dispute over whether a murder victim survived for a few minutes, if someone overheard a victim utter a statement, then that statement is relevant to prove that the person was alive. So doesn't matter whether the statement is true or even what the content of the statement is. It matters that the person could make a statement, which means they must be alive. Okay. All right. Hearsay exceptions. So if the statement does matter to the content, if the content of the statement is true, if it matters, if that makes a difference, then it's hearsay and it's only admissible if it falls into an exemption or an exception. There are two overarching categories of exemptions and exceptions. And these are prior statements of a witness and opposing party statements and admissions, okay? So, categories of exemptions. Does a statement have to be true to be relevant? No, then the statement is not hearsay. If yes, was the statement previously made by a witness or by a party opponent? If yes, then the statement may qualify as an exemption. So, first things first, prior statements by a witness. These are admissible if the person's available to testify and subject to cross-examination. We have three types of prior statements. We talked a little bit about some of these when we talked about impeachment: prior inconsistent statements, prior consistent statements, and prior statements of identification. Inconsistent statements contradict the in-court testimony. This is consistent with the present testimony. It is only admissible to rebut an express or implied charge that the declarant recently fabricated or acted from an improper influence. Statements of prior identification. These are out-of-court statements identifying a person after you have observed the person. And these are usually statements that are made during in-person lineups, photo lineups, or show-ups. These statements are often made to police officers in a police station. Sometimes, though, with photo lineups, it could occur elsewhere. All right, I'm gonna go ahead and stop this video here. I don't like to let these videos get too long because it gets time-consuming to find what you're looking for. But I will do a part 2 for this week as well, just because there is more content to work through on hearsay.